the position that it was a desire of the Kenyan people that nothing shall be beyond the reach of the court for purposes of giving redress. And that is the basis upon which we have been proceeding. I will end it up there and come to what he's more comfortable with. Jurisdiction with regard to purported ouster of the jurisdiction of this court with regard to impeachment of the president. My Lord, jurisdiction is actually not given in the manner that they are suggesting. My Lord, even for purposes of the governor, which he says is different, there is no provision under Article, I believe it's 181, that says, or 182, let me just confirm. Yes, my Lord, for purposes of the removal of county government under 181, the issue is none of those procedures actually says that after you are done with impeachment, you will go to the High Court.
The impeachment, Professor, this is not parliament. He has not sought your help. Please sit down.
Thank you, my Lord. I know that tactic. But, my Lord, the point I'm making is that even for purposes of Article 181 and 182 of the Constitution, there is nowhere that those provisions say that when you are done with impeachment at the Senate, you will go to the High Court. But nonetheless, people have been going to the High Court on account of jurisdiction as set out in Article 165 of the Constitution, the jurisdictions of the High Court. And therefore, my Lord, this requirement that, there is no provisions for going to court, it is neither here nor there. That is not the design of the Constitution. That question of jurisdiction has been settled by specific provisions of the Constitutions. My Lord, what about these issues that you needed to go to the Supreme Court? My Lord, for purposes of the jurisdictions of the Supreme Court, it has been settled very clearly. I believe it is under Article 163, sub-Article 3, and it is settled in a manner that it says in very, very conclusive terms. This is 163. I believe it is 2. It is actually 3 and 4. They completely settle what is within the jurisdiction of the Supreme Court. Their argument that you cannot arrogate jurisdiction would actually come into play in this particular manner if this court were to make a finding that this matter ought to go before the Supreme Court. Because effectively, you would be amending Article 163, 3 and 4 of the Constitution as to the jurisdiction of the Supreme Court. But my Lord, where you find comfort is that the jurisdictions of the High Court, and that's why it is a court of original civil and whatever and criminal jurisdiction, is that the High Court has jurisdictions in everything unless the Constitution says otherwise. And to deal with that when we come to the Senate, the moment, my Lord, you say the Senate was sitting in a quasi-judicial capacity, it is a design of the constitutions that any person who sits in a quasi-judicial capacity, there is a right to go to the High Court. There is no law in this country, not one, in which any person who sits in a quasi-judicial capacity, there is no remedy to go to the High Court by way of appeal, by way of Article 23, or any other manner. So that issues of jurisdiction is neither here nor there from the plain reading of the Constitution itself. So the other cases of Nixon, all those, they would be neither here nor there as far as we are concerned. Mr. Milimo talked about...
While you are still on that issue.
Yes, my Lord.
Dr. Ogada also addressed this, but what is your view on the submissions by Dr. Kinkuli about the constitutional history of
yes.
that issue?
That's very interesting, my Lord. I think I should say something. I was just giving myself additional pressure. My Lord, for purposes of that history, and incidentally, as a young lawyer, I was involved in all this process, courtesy of Muite Orengo and Dr. Gibson Kamau Kuria. so I can speak in with vast knowledge of some of these issues. My Lord, this Bomas draft constitution, you actually find it very interesting. We cannot go deeply into it. Precisely. My Lord, the issue that is important to note is that under the Bomas draft constitution, there was, first of all, impeachment was dealt as a justiciable issue, but it was justiciable at the Senate. So the argument that it was non-justiciable cannot be supported by the Bomas draft. And any other constitution that was actually talking about the issue of impeachment being justiciable, either at the High Court level or at any other level. But my Lord, the important issue would be how we traveled to the position that we are in today. And my Lord, the positions that we are in today, as my learned friend Mr. Ocheli is pointing out, is that when you compare, particularly Bomas draft and the current one, you'd actually see that the jurisdiction of the High Court was actually increased in the 2010 Constitution, and the jurisdiction of the Supreme Court was actually reduced in comparison to what it was under Bomas. So that, my Lord, we are in a happy situation that you arrived at a situation whereby the High Court is the main court for purposes of the 20 Constitution, which reinforces the arguments that we made. Democracy in this country fails or succeeds depending mainly on the decisions of the High Court. My Lord, I hope I've answered that issue of the history, my Lord, because of the usual pressure of time. My Lord, Mr. Milimo, I believe he made many points. I will choose one or two. He alleged that nobody is disputing that public participation was carried out properly or anything. My learned colleague, Mr. Sankipa, has pointed out to me that there are actually 5 affidavits that says that, and one of them was actually by Mr. Omoke, the advocate who was here, to say that the process was completely muddled up and they got it wrong. My Lord, the only other point that was made when Milimo was speaking was to say that the Speaker has no vote. It is true, we are aware of, all of us, the Speaker has no vote. But my Lord, everybody, and is actually the duty in the standing orders and in the Constitution, as a presiding officer in the National Assembly or in the Senate, the Speaker, there is a duty of impartiality. That is where anything you read about the Speaker, they talk about that. The duty of impartiality for purposes of the Speaker. For purposes of both Speakers, my Lord, they made the rules of impeachment. Those rules are the subject matter of what is going on. How you will carry out public participation, the calls that were made, is it going to be plenary, is it going to be committee? The most important one being, you could have held these proceedings until Sunday, you decided to read the rules to allow people to vote on issue of rights. My Lord, my knowledge of and Article 27 of the Constitution, matters of rights are not subjected to votes. Yet that is what happened at the Senate. So that's an issue that we shall be talking about when we comes to the hearing of the petition. So the Speaker is not a nobody. The Speaker, and for purposes of these proceedings as they happened, all those speakers, they made consequential decisions that have had serious implications in the matters that is before you. Mr. Gumbo, my learned colleagues, he says very many useful things. You wonder what to choose, what to leave. One of the issues that he said that is when he talked about prayer number C, the prayers that was granted, is to say very unsustainably that the only arguable thing is on the swearing in. My Lord, all those prayers were supporting a petition that is seeking at the Conservatory stage to to stop the impeachment process in a manner that preserves the subject matter of this matter. This is what we are arguing today, and my Lord, consider the issue on merits and make the relevant decisions. My Lord, he says that it is not tenable for this court to stop it. My Lord, that is exactly what these courts have been doing from all these many cases that have been cited. That in appropriate cases, decisions are made in a manner that upholds justice. The duty to do justice is an absolutely important one. You are told that Gachagua cannot be able to hold office because of Article 73(1) of the Constitution. That, of course, will be the case when he reaches the end of the road in these proceedings. End of the road will be Supreme Court, I am sure. But as of now, that issue does not arise. My Lord, as regards the issue of Article 148 to 149, I think we have said a lot about it, except, my Lord, when it is alleged that public participation under Article 149 is not required. My Lord, the issue is this. The Constitution is clear that from Article 10, it says whenever you are interpreting or applying the law, the values and principles in Article 10, which includes public participation, shall apply. What that means, if Parliament is carrying out a constitutional duty and Article 10 applies, unless it is excused by anybody, which I don't think it is possible, then prima facie, one cannot argue that public participation is not required. My Lord, the same argument would also follow under Article 118. It talks about legislative business and any other business before Parliament, which is exactly the issue about Article 149. Public participations would be required. So that, my Lord, prima facie, we are asking the court to hold, for purposes of the issues that will come for the petition, that prima facie public participation that was supposed to be conducted for purposes of Article 149(1) were not conducted. My Lord, coming to the issue of public interest, legitimate expectation that the positions be filled, I agree. But the law also must be followed in filling vacancies in public positions. That matter has been rehashed in very many, including in a case which we have cited, where a representative of the public to the Judicial Service Commission was involved. And the bench of this court was categorical, public participation was required. It would be the same thing when it comes to a person who is nominated, not elected, that such public participation be conducted. My Lord, when it comes now to...
My Lord, for purposes of information to the court, it is worth noting that the Supreme Court decision that has been read today has actually rendered almost obsolete all the previous arguments of the applicants. Just for that.
Do they say Article 118 of the Constitution requiring public participation is deleted from the Constitution?
My Lord, I hope his information will serve its purpose. My Lord,
I think you need to answer Senior Counsel's question.
It's actually, that decision will actually reverberate through all cases that touch on public participation. It has chattered, and we are happy that God has brought it at this time to us. So God is on our side.
My Lord, I wonder now whether it is Gumbo who was talking about Roscoe Pound. Is it you? Somebody was talking about Roscoe Pound. My Lord, I agree with Roscoe Pound, one of my favorite legal philosophers, when he talked about the issues of law as a tool of social engineering. And my Lord, the Constitution of Kenya is actually an important tool following the doctrines of Roscoe Pound as an important tool of societal transformation, as Dr. Willie Mutunga, CJ Emeritus, said in one of the famous decisions. And therefore, I would not agree with him more. And my Lord, I would only point out to the fact that in following Roscoe's Pound, it is a reason why we have Article 10 on the ethics and principles of governance. It is a reason why we also have Article 259 of the Constitution that says how you are going to interpret the Constitution's rule of law, values, Bill of Rights, all these things are mentioned. So I agree with him that the Roscoe's Pound is actually codified for purposes of the Constitution of Kenya. And my lord, that is something that you must bear in mind, that constitutional litigation in this case is a value-based system. It is not any other different. My lord, on Paul Nyambodi, I believe we are not engaging in any merit review, and therefore there is nothing much to say about what he was saying. But my lord, the only important issue that we would like to say is that Article 23 actually says that amongst the reliefs that can be given when one is seeking to enforce fundamental rights under Article 22 of the Constitution are these orders. One of them is conservatory orders. So that is also an important issue to bear in mind. And my lord, the final point that I wish to make, not because there were no other points, is to point out the fact that the old favorite case for most of us that we had pointed out to answer the other global issues that have been made, to emphasize the issue of justice. My lord, in the Gachagua'S case, the deciding point was this. It was not that Gachagua'S was an innocent man. They made it that very clear. Gachagua'S could as well have been guilty for the offense that he committed. But what moved the court was to say, the Attorney General cannot say today, we shall not prosecute, you go back, sit pretty, forget about answering any questions, and then you are called upon at some other stage by another Attorney General, kuambio kufungulio mashtaka upya. What they say, to use their precise words, is that a prosecution is bad at the start, not at the end. My lord, in this particular case, we are saying that the manner in which these impeachment proceedings have been carried out, it has been carried out, as we have tried to demonstrate, badly from the start during the process. I urge the court to ensure that this bad process is arrested. Even when we did not have a serious constitution to preserve those kind of due process rights, which are what we are here to process, Justice Madan protected the due process under the law. During our circumstances, arguing in October 2024, there is a constitution that says in no less than 10 articles that in doing substantial justice, a certain way of doing things is the only way to do it. If we were to say that it was possible to do due process in 1986, how much more can the High Court do? Your Lordships and my lady, I urge you to confirm the Conservatory order and to dismiss the applications to seek their setting aside. I am most obliged.
My ladies, my lords, only one point that my learned friend has escaped his mind is the submission of Mr. Bilimo that the Senate, sitting as a quasi-judicial process, cannot then engage in public participation under Article 118. That's a misconception because the Senate sits as a quasi-judicial process when it sits to listen and to hear the case. The presiding period in the preparation of the hearing of the case is when they are supposed to commence public participation. And the concept of quasi-judicial process does not oust the constitutional obligation under Article 118 to conduct public participation.
Yes. Yeah, whether you had made a judicial promise that I would respond to Mr. Chair.
He's not for later.
No, he did. He made submissions on the case of Samuel Ngong, and you indicated that I would make a response. I'll do that in 1 minute. About the case of Samuel Ngong versus Alpha related to a gazettement. I'm just distinguishing the case. A gazettement of one of the 9 members of the board of Alpha. The court initially granting a stay, my lord, because the initial stay did not, conservatory did not affect the functioning of the board. And there was a subsequent gazettement because he had been nominated by 2 organizations. My lord, the distinction here is that the position of the deputy president is in a unique position as defined by Articles 130 and 131 of the Constitution. Therefore, that case will not apply. There are many board members, about 8. This is a single position. Does not apply. As distinguished, my Lord, as the impeachment of the Deputy President under Article 145 and the impeachment of a governor under Article 181 and Section 33 of the County Government Act, which is statutorily underpinned. Very distinguishable. All the cases they have cited are irrelevant on governors. The impeachment of a Deputy President is unique and is final under 145(7) because it is constitutionally underpinned and not statutorily underpinned. You can't object or finished. That's all.
My Lord, with tremendous respect to the court, we have had the opposition from the other side on our right to rejoinder, but we would like a court to pronounce itself, because the record will reflect our representation from when the case was transferred from Eldoret to this court has never changed. The law firm Mr. Murara operates in is the same law firm that we work and filed this petition under. And this is not a new thing. Even in the BBI case, Mr. Murara was a petitioner and appeared with the council.
What is the issue?
It's the right to rejoinder. We have not been given an opportunity.
Lord, we have something to say on that. In the petition which Mr. Murara filed in Eldoret, he filed a petition in person. Today he appeared in this court and urged certain points in person. There are certain matters which he made, and even the professor raised an issue seeking to cross-examine him. And then it turned out that he appears in person. So we need a notice of change.
There is no need.
Notice of appointment of advocate for now Murara to instruct counsel to represent him in these proceedings. That is the extent of my objection.
I thought, my Lord, you ruled on it unless you're being asked to revisit your ruling.
You have notice of appointment.
My Lord, there is no need for a notice of appointment. The record will reflect that the firm, the pleadings are not filed by Murara in person. They are filed by the law firm. And Mr. Diankol also appeared with Murara in fact, with the BBI matter. So I don't understand why he would object now that the case went up to the Supreme Court. I only request for 5 minutes.
I think we have come to the end of today's proceedings. We want to take this opportunity to thank you all, counsel who have presented their plans, cases, and even people who came to see the proceedings. We have sat until late. We shall render our ruling on Thursday at 2:30. Thursday is Tuesday. A day after tomorrow, 31st at 2:30.
My lords, perhaps I need your guidance because we are indicated in the morning that we have an application for contempt of court, for which
Mr. Ndegwa, listen to the instructions and directions of court. We will give a ruling on this matter on Thursday the 31st at 2:30. After that, we'll provide a way forward for any other matter. Thank you.
I want to take it.
Please sit down.
Yes.
So we see you on Thursday.
At least it's not tomorrow.
No, that's very good. We'll be hard on Thursday. Now we have to tell them they can arrest the judge.
But yeah, thanks. It was good,
These students online. Assistants.
Maybelline New York New Lifter Plump. Warning. Intense heat. Lasting plump.
It's easy. Techno, stop at nothing.
The world was excited, well, over a week ago when Mekzila eventually